A school education is the right of every child in Australia. National and state governments legislate the responsibilities of those providing school education and the conditions under which substantial government funding is provided to support schools. Schools are an essential part of modern life, and the people in them must adhere to many laws which apply to the whole of society. A school's legal compliance framework identifies the applicable laws, sets up systems, policies and procedures to ensure compliance. It also assigns responsibilities to key personnel who are accountable for the school's compliance with these laws. What's more, it's a legal requirement in New South Wales. All schools must have a legal compliance framework for good governance and to be registered to operate by the New South Wales Education Standards Authority, or NESA. This requirement is part of the policies and procedures set out in the NESA school registration manuals. The manual states responsible persons are accountable for ensuring policies and procedures to manage legal compliance and to document the process. The laws governing schools are the same for every not-for-profit, non-government school in New South Wales. It makes sense that governing bodies managing systems of schools apply the same legal framework to each school. There should be consistency in delegations and reporting mechanisms between the System Authority, the Catholic Schools Office, CSO, and each system school. School principals may assign compliance responsibilities to different roles within the school, but the basic legal framework applies to all schools. In this module, we will outline a general approach to designing a legal compliance framework and provide an overview of some key legislation applicable to Catholic schools in New South Wales. It is important to note that the information in this module does not constitute formal legal advice. The information given is of a general and indicative nature only. Module users are directed to obtain formal legal advice if particular compliance concerns arise. That said, let's start by hearing from the first of three legal experts. Ian Baker is the Director of Education Policy and Programs at Catholic Schools New South Wales. As an educator and lawyer, Ian has been advising its predecessor, Catholic Education Commission New South Wales, and the state's Catholic schools on all aspects of legal compliance for the past 30 years.
There's quite a number of laws that govern how schools are meant to be run. What are some of the main laws governing school education that we need to be aware of?
Well, Jim, we first, as Catholic educators, should be aware of our own canon law. The canon law speaks to Catholic schools. Canons 793 through to 806 set out the Church's requirements for the operation of an effective Catholic school. One of those requirements is that it be at least as educationally efficient, if I can use that word, as the neighbouring government school. But then we have a whole range of state and Commonwealth laws. Given that Australia is a federation, we have the joy of two parliaments, two sets of laws. There are about 49 different state laws that touch upon schooling in different ways, and about 26 Commonwealth laws. And the Commission publishes a guide to these laws.
Can you give us a background to some of the main legislation?
The key legislation that school administrators absolutely need to be aware of are first of all, the Education Acts. And because we're a federation, there's a State Education Act, the New South Wales Education Act 1990, and the Australian Education Act, which is the Commonwealth Act of 2013. They're the principal acts, but in addition, in New South Wales, we have the NESA Act, the Education Standards Authority Act, which is actually a very new act. And then we have, at the Commonwealth level, a number of acts which impact on schools, but don't have school in the title or education. For instance, the Australian Charities and Not-for-Profit Commission Act. That act is fundamental to our schools as charities, because our schools have two legal identities. They are schools registered under the New South Wales Education Act, but they are also charities and therefore need to be compliant with the Charities Act. The Australian Education Act 2013 and the companion regulation set out a number of accountability requirements for schools. Financial viability of the school, that the school has met fit and proper person requirements in relation to anyone involved in their governance, that the school has processes for enhancing principal and teacher performance, that the school is implementing the Australian Teacher Performance and Development Framework, that the school is participating in the National Assessment Program, NAPLAN, PISA, and that schools participate in data collections such as the NCCD, the Nationally Consistent Collection on Data of Students with Disabilities. And then there are other requirements such as A2E reporting, which I mentioned earlier. A2E reporting is actually a requirement of the regulations.
And what about at the state level? What legal requirements do we have to observe because of the New South Wales Education Act?
The New South Wales Education Act evidences itself for schools, and particularly school principals, schools administrators, in the requirements for school registration. Also the requirements to operate a school on a not-for-profit basis. Schools would be familiar with the school registration manuals of NESA, which set out those requirements. Then there are the not-for-profit requirements, which are actually managed by the Ministry of Education here in New South Wales and the Section 83C guidelines. And then in addition, of course, there are the teacher accreditation requirements. So the list, I suppose, is long, but that goes back to our duty of care and our moral and ethical purpose that we want to, and we need to, as a matter of law, operate schools which are efficient, effective and safe.
A lot of people would have heard about the Gonski Review, and if they know anything about it, they know it means something to do with money for schools. But Gonski raised some compliance issues as well, didn't it?
Yes, Gonski is much more than just funding. Funding's absolutely fundamental. Funding's necessary, but it's not a sufficient condition, if we can use that language, to have an effective school. So the first Gonski report, delivered in December 2011, definitely traversed the territory of outcomes and accountabilities and how to link funding to performance. So Gonski is very much about performance, not just funding. We also have the ACARA Act. ACARA, the Australian Curriculum Assessment and Reporting Authority, is established under its own Commonwealth Act. And that ACARA, as everyone in schools will know, manages the My School website.
Apart from the Education Acts, there are quite a number of other laws that principals need to be aware of as well, aren't there?
Yes, Jim, we've already noted that my office tracks some 46 state acts and some 29 Commonwealth acts, and we are aware of the compliance burden, and we do work with government to try and ensure that the compliance environment is manageable. The key acts which schools would be familiar with, in addition to the Education Acts, would be the Privacy Act for the management of student information and indeed staff records for that matter. Disability Discrimination Act, which governs the enrolment of children with disabilities and also the provision of ongoing education to students with disabilities. We have the Copyright Act, which is of more and more importance to schools because of all the electronic devices. Electronic devices are of little use to schools without content, so that immediately triggers the Copyright Act.
One of the areas that faith-based schools are often dealing with is the Anti-Discrimination Acts, federal and state. What do we need to keep in mind there?
The principal laws would be the New South Wales Anti-Discrimination Act, 1977. Then we have a range of Commonwealth Acts, and I'll just mention two of those, the Commonwealth Sex Discrimination Act and the Commonwealth Human Rights Commission Act. Now, those acts, of course, have to address the reality of competing human rights, a range of human rights. And Australia is a pluralist and multi-faith society. And so we acknowledge that sometimes rights can come into conflict. All anti-discrimination legislation, both state and federal, provides protection for religious bodies and in particular for schools operated by those religious bodies. That is to say, a school operated by a religious body can develop enrolment policies and employment policies to protect the integrity of the school. I'll actually read the wording, and this is taken from the Commonwealth Sex Discrimination Act, that an educational institution that is conducted in accordance with the doctrine, tenets, beliefs or teachings of a particular religion or creed, and of course for us that is Catholicism, can discriminate if the action is undertaken in good faith in order to avoid injury to the religious susceptibilities of the adherents of that religion or creed. Obviously that has to be done in a sensitive way and with respect to the whole range of human rights, which a complex, pluralist, multi-faith society such as Australia experiences in the day-to-day life of all of us as citizens of such a complex society.
Ian Baker, Director of Education Policy and Programs at Catholic Schools New South Wales. Let's review the key points he made. Catholic schools are part of the mission of the Catholic Church, so canon or church law is an essential part of the governance of Catholic schools. There are at least 49 state laws and 26 Commonwealth laws that affect schools. The Australian Education Act 2013 sets out a range of national educational requirements. State educational requirements are set out in the New South Wales Education Act 1990. Schools must also observe the financial requirements of the Australian Charities and Not-for-Profits Commission Act and Section 83C of the New South Wales Education Act and the New South Wales Not-for-Profit Guidelines for Non-Government Schools. School registration is regulated by the New South Wales Education Standards Authority. Other laws impacting schools include the Privacy Act 1988 and Privacy Reform Act 2012, and the Disability Discrimination Act 1992 and the Disability Education Standards 2005, the Copyright Act 1968, and state and Commonwealth anti-discrimination laws, which aim to balance religious freedom with competing rights. We're going to focus now on two of those other laws that affect schools, the Privacy Act and the Copyright Act.